pleadings that this is not standard poultry practice. We specifically allege that they disregard poultry industry norms. And the things that they're doing don't serve any purpose, at least as the complaint alleges them, which is, again, where we're at in the stage of the pleadings. That boiling chickens alive, or leaving them in the hatcher too long so they starve and die, or transporting them in trucks where they fall out and get run over, intentionally running them over, which is a separate allegation from leaving them in transport trucks.
Good morning. Welcome to the North Carolina Court of Appeals. I'm Judge John Airwood. To my right is Judge Jeff Carpenter. To my left is Judge Tom Murray. And we're your panel today for the one case of legal impact for chickens versus Case Farm LLC. I want to thank our clerk staff and the security staff for helping us today. Welcome all the visitors as well. And we will hear from the appellant.
May it please the court. My name is Dan Gibson. I represent Plaintiff Appellant Legal Impact for Chickens. With me here also is Legal Impact for Chickens founder, Aline Anello. I'd like to reserve 10 minutes of my time for rebuttal. The question in this case is whether a complaint alleging detailed, specific animal cruelty that violates the law states a claim under North Carolina's animal cruelty statute. Applying the law as written to the complaint as written says that it does for two reasons. First, the detailed facts in the complaint show cruelty. The complaint specifically alleges that defendant's cruelty is not conducted for the primary purpose of providing food for human or animal consumption. It also alleges that those acts are unlawful. Among other things, it alleges that in violation of USDA regulations, defendants routinely send chickens into the scalding tank alive and fully conscious. And it alleges intentional cruelty with the full knowledge of Case Farm's management. Those acts are not for a proper purpose, and those acts are unlawful. And it backs those allegations with specific factual pleadings on the cruelty alleged. Among other things, it alleges that defendants run over chicks, starves them, crushes them, tramples them underfoot, transports them in trucks that it knows they will fall out of, leaves them to overheat and die, and buries them alive. The USDA noted a pattern/trend of handling poultry that is unacceptable to the USDA. All of that is alleged in the complaint. Taken as true, those facts state a claim under North Carolina's animal cruelty law. Rather than taking them as true, the trial court disregarded the complaint's allegations and created a categorical exemption for the defendants, saying that the statute was inapplicable to the defendants.
So did the trial court create that exemption, or did the General Assembly create that exemption?
The exemption in the statute is for lawful activities. Well, there's two relevant exemptions. One is lawful activities for the primary purpose of producing food for human or animal consumption.
Now, is it your contention, it seems to be your contention, that any time a chicken dies before it can be consumed by animal or human consumption, that takes it outside the realm of the exemption? Is that your contention with respect to the statute?
That is not my contention. So let me explain.
That seems to be your contention in your brief.
Let me explain how I think the statute works here. I think first you have to have a prima facie showing of cruelty to come within the orbit of the statute itself. And then once you've made that showing of cruelty, the defendants can show that there's an exemption, whether it's producing poultry or producing food for human or animal consumption. They have to show that it's for that purpose and that it's lawful. And once they've made that showing, then obviously we could present rebuttal evidence, and the finder of fact could weigh that evidence. When it comes to the killing of chickens, what we're concerned with, particularly in that context, is the slaughter of chickens, because federal regulation governs the slaughter of chickens. It says they need to be slaughtered in accordance with good commercial practices, and that means that breathing has to stop prior to them going in the scalding tank. So the boiling chickens alive allegation relates specifically to defendants violating federal law. Our argument is if you're
Now,
slaughtering...
is this a federal law? Is this a USDA regulation? What is?
It's a USDA regulation. It's 9 CFR 381.65, and North Carolina has adopted USDA regulations in our North Carolina Administrative Code. So we have our own state Poultry Products Inspection Act, which is the congressional law that the federal regulation is under. And our state Poultry Products Inspection Act mirrors the federal Poultry Products Inspection Act. The biggest difference is the federal law governs interstate commerce. North Carolina's law governs intrastate commerce. So if the chickens are going from Raleigh to Richmond, then federal law applies. If they're going from Raleigh to Charlotte, then state law applies. And we have expressly adopted the same federal regulations in our administrative code. So the law here all harmonizes and works together. What's unlawful under federal law is also unlawful under state law. I think it's noteworthy that in the complaint, we in fact specifically cited that regulation of federal law. That's paragraph 135 of the amended complaint. When we say that they violate USDA regulations by routinely sending chickens into the scalding tank alive and fully conscious, that paragraph allegation drops a footnote which cites 9 CFR 381.65 and includes the relevant regulatory language that they need to be slaughtered in accordance with good commercial practices. So our allegation there is if you're improperly slaughtering chickens in a way that's cruel, and there's no argument that boiling chickens alive isn't cruel, you don't get the statutory exemption if you're violating the law within the process of slaughtering chickens. Outside of that, the other cruelty that we're alleging, for example, intentionally running chicks over. We would allege that intentionally running chicks over is cruel. I think there's no argument that that's not cruel. And we'd allege that because that defeats the statutorily exempt purpose of producing poultry, there's no way that that's part of the process of producing poultry, because it prevents chickens that get run over don't become chicks that you can then sell for food or otherwise sell or market as part of interstate commerce. So the argument there is if we allege a cruel act that prevents the purpose that you're trying to achieve, at least at this stage of the pleadings, that needs to be taken as true. You need to read the inferences in the light most favorable to the non-moving party, so on and so forth. Then we've shown, we've not just alleged that it's not for an exempt purpose, we've also shown that the actions themselves defeat the exempt purpose. I think it's noteworthy here.
But if we take your interpretation of the statute, or your client's interpretation of the statute, doesn't that then basically do away with the entire exemption about poultry?
I don't think it does do away with the entire exemption of poultry. Again, you have to first say that it's cruel, and then you'd have to look at the specific activity being alleged in the complaint. So you need to look at what the complaint alleges. And I think it's noteworthy here that the complaint alleges, among other things, that this is not standard poultry practice. We specifically allege that they disregard poultry industry norms. And the things that they're doing don't serve any purpose, at least as the complaint alleges them, which is, again, where we're at in the stage of the pleadings. That boiling chickens alive, or leaving them in the hatcher too long so they starve and die, or transporting them in trucks where they fall out and get run over. Intentionally running them over, which is a separate allegation from leaving them in transport trucks, or withholding food and medicine, the use of the conveyor belt that simply always kills or injures a few chickens. These are acts that don't further that legitimate purpose. So the question would be, if you have a complaint making these allegations, do you make a prima facie showing under the statute? And the law there, again, is very well established. This is just 12b6. It's the same thing we do with every other complaint or any other affirmative defense. The defendants pleaded the statutory exemption as an affirmative defense. We know that when you're looking at a Rule 12b6 motion, you take the facts as true. To fail under Rule 12b6, the complaint itself must disclose the defect. And our argument there is that purpose within the statutory language is a question of fact that needs to be determined by the trier of fact.
When you say purpose, what do you mean? Using it in the context that you just used it, what are you talking about?
So when I say purpose, I mean the statutory purpose, which is the purpose of producing poultry or other species, or the primary purpose of providing food for human or animal
It
consumption.
seems to me from your brief that you presuppose a definition of legal or lawful in your interpretation as you've briefed. Are we talking about each individual process that a processor would go through to get the chickens to the point of being consumable, or are we talking about the growing of chickens generally, whether that's lawful? It seems to me that you're presupposing the former and not the latter.
So there's a few things there. First, the way we read the statute, there's two parts of the exemption. One is the lawfulness, and the second is the purpose.
Lawfulness of what? That's my question.
The lawfulness of the activity per the terms of
What
the
is-
statute. So the question is,
We're getting somewhere.
yeah.
What's the activity?
what's the purpose of that?
What's the activity?
Yeah. So I think when we're looking at the activity, I understand the defendant's concern of getting too granular and saying, well, if a farm has a piston that malfunctions one day, and then you sue and you say, well, you violated the statute, and the next day they fixed it. First of all, I don't think that lawsuit would get very far. You'd go to court and you'd probably argue that it's moot. We fixed the problem. But where we're at in this complaint, again, I keep coming back to the allegations of the complaint themselves, that this is routine, regular misconduct.
Yeah, I guess, so you probably have a different lens than maybe I'm viewing it from, but to get to the point of it has to be unlawful, right?
I think so, yes.
You're presupposing a definition of what a lawful activity is by getting into the granular details of what's happening. Maybe there's some shortcomings, and I think your opposing counsel has taken the position the lawful activity that we're talking about in the statute is the production of chickens for human or animal consumption. Is that not a question of law for the trial judge to determine? It's not, you're focused on facts. Is there a question of fact? But there's also a question of law that must be determined as a precursor to you getting to the point of a judge determining facts. You didn't demand a jury trial here, so it'll be a bench trial.
Yeah, the statute actually specifically requires a bench trial here. So I agree with you that the question of statutory interpretation is a question of law. Then applying that statute to the facts arguably makes question of law and fact, but there's definitely fact questions involved. What I think is an interesting question in this case is, do you, looking at the facts alleged in the complaint, get to the level of the activities, the unlawful activities are so pervasive that they overcome the argument that the activity here is a lawful activity. And that's why I think it's important that the complaint alleges that these are routine misconduct. Among other things, the complaint alleges that the cruel acts are done repeatedly pursuant to the standard operating procedures of the hatchery. The USDA again noted a pattern and trend of improper handling of poultry at the slaughterhouse. We allege that the defendants operate their facility in a manner that causes unjustifiable cruelty, suffering, severe injuries, and death to chicks. And that's tracking the statutory language, that these are routine practices that are part of the pattern and practice of the defendants. So you can imagine on a spectrum, you've got that earlier example that I gave you of a piston that just malfunctions one day. And then at the other end of the spectrum, you've got a piston that always malfunctions, and there's no plan to fix it. That's actually what we alleged in this complaint. You've got a conveyor belt system that moves the chickens around. The piston is slamming chickens, killing them, maiming them, injuring them. Again, everyone agrees that that's cruel. I think if we're looking at just that one event on one day, maybe it doesn't overcome the lawful exemption. But when it's a pattern and practice that always does this, and when it's not just one pattern and practice, but it's 9 different pattern and practices that have been observed by the USDA, at that point, regardless of whether you interpret the law to say, well, do you look at the activity as a whole? Well, if you look at the activity as a whole, as alleged in the complaint, the activity as a whole is routinely and regularly violating the law. And when you're routinely and violating the law, you don't get to say we're engaged in a lawful purpose anymore at that point. That's why I say I think there's fact questions there. Because if the complaint alleges that it's routine, it's a pattern and practice, I think read in the light most favorable to the plaintiff, taking all inferences in their favor, is there any state of facts the plaintiff could prove that bring it outside that statutory exemption? The answer is yes. When you've got a pattern and practice of routinely violating the law, you can't say, well, we're engaged in lawful activities.
If your district court judge views the statute such that what he or she is determining is lawful or unlawful is the actual processing of chickens, I'm baffled by how that's not a determination of law. The judge can say the process of producing chickens for human consumption is what I'm determining is lawful or not. You are getting into the details on your side. You want the law to be interpreted about each of the individual pieces of the process have to conform to certain aspects. That seems to be a USDA thing, not a judge looking at it from a broad perspective thing, or at least that's how I view the judge's ruling here. I'm not sure that it was a determination as to whether or not there's questions of fact left. It seems to me that the judge was making a determination as to questions of law.
Well, I think that the trial court judge's specific language here is instructive, which is that the trial court judge said the statute is wholly inapplicable to the defendants. It didn't look at whether their conduct was lawful or not. It just said it's wholly inapplicable to them because they're farms.
Why do you think the trial judge made that determination?
That's a good question, Your Honor. I'm not certain. I don't think that that's a proper way of reading the statute. If the trial court judge had said lawful activities includes farming, the defendants have shown that they're engaged in farming, then I don't think I'd be making the same argument. But I think maybe the trial court judge, if I had to speculate, knew that they're not supposed to determine questions of fact. And the way that I just stated their ruling, that farming is a lawful activity, the defendants are engaged in farming. Farming is a lawful activity is a statement of law. The defendants are engaged in farming is a statement of fact. That's a fact question. And that gets back to that fact-law distinction that I've been trying to make clear here, which is how you interpret the statute, yes, is a question of law. Then the application of that statute to the facts as alleged in the complaint is a question of fact. So,
Well, but the statute specifically says that for the purpose of producing livestock, poultry, aquatic species, or for the primary purpose of providing food for human and animal consumption. Your interpretation seems to say that, and that's why I'm going back to what I thought your brief was to begin with, that you've got to look at each one of these acts separately, and that running over the chicks is not that, or the conveyor belt is not that, that you don't look at it as a linear process, but that you have to look, that we're supposed to determine that each activity has to be lawful in order for it to fall within this continuum.
I think that's one way to read the statute. I think even if you read the statute to say, look at the whole activity, if you read it that way and then you apply the facts as alleged, we're alleging the whole activity pursuant to the standard operating procedures with the knowledge of case farms management is routinely operated in a way that produces all of these different aspects of cruelty from the beginning of the process to the end. That's one of the reasons why our statement of facts starts with chicks are born and they starve. And then when they get to the end of the process, they're boiled alive. There's cruelty throughout the entire process that's routine and regular. So even if you're looking at the activity as a whole and saying, well, let's look at the whole process, our complaint alleges every step along the way that there is routine and regular cruelty that either is not for an exempt purpose or is not lawful, and that is with the knowledge of case farms management. So if you look at the activity as a whole, the way we've alleged it here, even if you're looking at it as a whole, they're wholly disregarding the law. They're wholly falling outside of the statutory purpose.
By the law, you mean they're disregarding USDA regulations.
USDA regulations and the relevant, the coordinating North Carolina law.
But didn't the General Assembly empower the North Carolina Department of Agriculture and Cultural Services with the regulatory oversight for this process instead of the animal cruelty statute? How do you square that circle?
So I think the way that you square that is there's different levels of involvement here. So at the highest level, you've got the USDA. If USDA wanted to come into Morganton, I think the Department of Agriculture would say, this is interstate commerce, you have authority. I think if the Secretary of Agriculture, the next step down, wanted to come in and say, you're violating the law, I think the USDA would say, all right, you go ahead. This is a North Carolina poultry farm. You can do it. The statute 19A also empowers animal cruelty inspectors, nonprofit or unpaid animal cruelty inspectors that can come in. So that's another level. And then we create a fourth level here, which is a civil remedy for the protection of animals. And that, in fact, was the title of this statute when it was first enacted. The General Assembly made it clear that it's trying to create a private cause of action. And that's why they've written the statute broadly. This is an incredibly broad cause of action that
But haven't they also written the exceptions? If we say that the statute is written broadly, don't we also have to, the exceptions look pretty broad to me as I read them. It looks like perhaps even that the Farm Bureau may have written the exceptions. So it looks pretty broad. So aren't we interpreting what the legislature meant by these exceptions?
So this court's precedent is when you have a remedial statute and you
I'm
have...
familiar with the way that we do it, and I'm now cutting into your time.
I'm happy to continue,
Okay.
but so there's two parts of that. One, as you already know, we narrowly construe statutory exemptions. Two, there's a common law background here, and when you're abrogating the common law, you narrowly construe that. On the Farm Bureau point, I want to point out something that I noticed in Farm Bureau's brief. They say on page 15 of their brief that agricultural practices that are lawful, i.e. those that are generally permitted or allowed, are exempt from the act. I think that's a perfectly fine statement of law. I don't disagree. But we're talking about agricultural practices that disregard poultry industry norms and violate the law. We've cited a federal law that they violate. We've also cited a state law that they violate. I don't think you get to claim the benefit of a statutory exemption premised on lawfulness when you are regularly and routinely violating the law. At the very least, whether those violations are routine and regular is a question of fact that the trial court should have determined here. With that, I'll reserve the rest of my time for rebuttal.
Thank you. We'll hear from the appellate.
May it please the court, your honors. My name is Rebecca Cheney and I'm from the Mecklenburg County Bar. And I'm here on behalf of the case farm entities who are the defendants and the appellees. By enacting the exemptions in question before you, the General Assembly intended to prevent exactly this type of intrusion and monitoring of agribusiness in the state. And we know this from the plain language of the statute, from the legislative history, and from the policy implications. And I'll start with the plain language. The plain language exempts the exact allegations or the exact conduct that's alleged in this complaint. To be clear, there are no factual determinations that need to be made here or had to be made in the trial court. As alleged, Case Farms qualifies for this conduct, qualifies for the exemptions. As you know, the exemptions are for lawful activities for the purpose of food production or producing poultry. And the allegations of the second amended complaint fall squarely within these. And I feel the need to pause for a minute and talk about the allegations because they are such difficult allegations to read. To be clear, Case Farms disputes them, but we understand that today what we're doing is taking them as true. But even as true, we fall squarely within the exemptions because everything alleged in the complaint is in the purpose or in the process of hatching, raising, and slaughtering poultry. Every single thing. In fact, if you went through and parsed the allegations, as we have, routinely, the appellants state that things that Case Farms allegedly did are protocols, are processes, are in fact, as he said, standard operating procedure. And I would urge your honors to look at paragraphs 51 and 101 of the alleged complaint, where it is alleged that the cruelty is systematic and it is standard operating procedure, and that it is done with the knowledge of management. Again, we don't concede that, but those are in fact the allegations. There isn't a single allegation that Case Farms is doing anything other than a process to raise chickens and produce food. So back to the...
How do you respond to Mr. Gibson's argument that the process has to be, quote, lawful, and that that's an extra layer, not just that it has to be a process, but that it has to be that the activities within the process have to be lawful, and that if they are cruel, then they're unlawful and therefore bring you outside the exceptions?
Mr. Gibson and I are in agreement that the first part of the analysis is lawful activities, but you determine the lawfulness of the conduct on a macro rather than a micro basis. So rather than parsing each thing that happens, the legislature intended us to say, is the activity as a whole, is it lawful? And the legislative history is interesting on that. I don't think we did a great job in our brief of pointing out the fact that there is an article by Professor William Reppy, a Duke Law professor, who was literally on the Legislative Committee and the General Statutes Commission in 2003 when these exemptions were drafted. And he wrote an article 2 years later in a law review, for Animal Law Review, in which he said, in order to benefit from the exemptions, the person causing the pain, the suffering, the death of an unjustifiable pain, suffering, or death to an animal must be conducting his enterprise in a lawful manner. So first, you determine lawful on an enterprise basis. And the example he gave, and he didn't like these exemptions. So the example he gave of how the exemptions work is a veterinarian. As you know, there's also an exemption for those. At a veterinarian's practice, his enterprise was lawful, according to Reppy, if he was properly licensed, okay? And if he was properly licensed, then this statute doesn't apply to him. There are other ways to police his conduct. But if the veterinarian was unlicensed or not in good standing, then this statute could apply to him.
Yep.
Now,
Professor Reppy does not particularly like this statute, as I seem to read his law review article.
I agree, Your Honor.
But he does say, I believe, at some point that the lack of lawfulness cannot be predicated on the violation of the animal cruelty statute.
Correct. Or its criminal corollary.
And I guess my question is, where in the legislative history do we, I know he was at the legislature at the time, but where in the legislative history do we find support for that?
Well, so if you look at the legislative history, you'll see that in 2003, when they were looking at these exemptions, there was a movement to change the lawful activities language to say that the exemption only applied to conduct that was within industry standards. I'm not quoting exactly, but it was an industry standard regulation or a good commercial practices standard. And so the legislature actually considered making the exemption apply almost as a negligence basis, right? And so there would be allegations, or you would have to determine whether the practices were good commercial practices before you could apply the exemption. But that was changed. And instead, they stayed with lawful activities, which Professor Reppy, who was boots on the ground, tells us was meant to be applied at an enterprise level. I would also like to point out that I disagree with Mr. Gibson's argument that even looking at it our way, at an enterprise level, that the conduct is unlawful. He cites to the Poultry Products Inspection Act, both the state and federal one, to say that the operations of Case Farms were unlawful. And I believe that is an incorrect statement of law. The Poultry Products Inspection Act certainly polices the kind of behavior that happens that's alleged in the complaint. But a notice of violation or a a request for an interview doesn't make the whole enterprise unlawful, and there's no allegation that it does, right? What is alleged in the complaint is that there have been historical violations of the act, as one might expect in any large processing plant, that there would be some violations. All right. Your Honors, I would also urge you to look at the policy implications of this law. And as our Supreme Court has said, one can look at the policy implications, or legislative intent can be inferred from the consequences which would follow. And that's a statement from our Supreme Court. Let's think about the consequences which would follow in this instance. The statute gives standing to any person. The statute also requires that these cases be heard by district court judges, whose dockets are full of the people's business. Divorces, car wrecks, fender benders, misdemeanors, they are busy. And under plaintiff's reading of this statute, what would happen is any person in any of our 100 counties could file a complaint, and if it was sufficiently detailed, allege that Case Farms or Tyson or Smithfield or even the individual farmer himself was doing something that was cruel. And then we'd be in court. And under their reading, there really couldn't be an early dismissal of the case, because to hear them say it, lawful activities must be analyzed on a case-by-case basis, purpose must be determined, that's a factual determination, so nothing would ever be early dismissed. And then, if you look at what the remedies are under this particular statute, the remedies are very broad. It says that the court can enter an injunction, that it can take animals out of the possession of the defendant, place them elsewhere. It can terminate ownership of millions of chickens and millions of hogs. Think of that. And that it also gives the district court the power to enter such orders as it deems fit and proper. Or I'm not verbatim there, something quite similar. How's that going to be enforced? So let's say in Burke County District Court, this complaint were to go forward. And let's say the judge were to issue an injunction. Now, they've requested a very vague injunction that wouldn't itself be enforceable, but let's assume that the district court does make some sort of detailed injunction order directing Case Farms to do or not do something. How will that be enforced? I mean, one would presume it would be show cause hearings, right? And then depending on the pockets of the plaintiff, that could be repeated show cause hearings. So what we're asking for, or what they're asking for, is a system that would permit individuals, activists, whether individuals or nonprofits, to make our district court judges continual monitors, receivers almost, of agribusiness throughout this state. And that is an unworkable system. And for that reason, Your Honor, Case Farms asks that you uphold the district court's ruling. To be clear, one of the things that Mr. Gibson and the plaintiffs have brought up is that the order, they read the order to exempt Case Farms completely from the statute. We are not contending that. We understand that the statute exempts conduct, not entities. However, our argument is we read that order to exempt Case Farms from liability or from suit on the actions pled. And that's what we are saying here today, that on the allegations pled, Case Farms qualifies for the exemption.
So my question is, if the remedy is not appropriate under the animal cruelty statute, how do, if we take the facts as true, how did they get fixed? How did those things get fixed?
Well, there are a couple ways. One is the Poultry Products Inspection Act. There are inspectors who come routinely. They do cite things they think are wrong, and they consider the directives in the statutes and the legislative, not the legislative, but the advisory publications from both departments encourage the inspectors to look for animal cruelty because they consider that to be an adulterated product. So there is statutory authority for inspectors to go in. And although it is rare, they do, if you read that law, the inspectors do have the ability to stop the line, to reject product. So an inspector could, If
The
they were
the inspectors, are those state inspectors that you're referring to, federal or both?
both,
And those are executive branch operatives, I presume?
yes. The second issue is publicity. Bad publicity matters, and I think the court can take judicial notice that Chick-fil-A does not want to buy chicken that's been cruelly treated. The McDonald's doesn't want to buy chicken that's been cruelly treated. So bad publicity matters, and it does regulate conduct. And third, case farms' own economic interest. They have no interest in killing chickens before they can be processed and sold. They have no interest in allowing employees to behave as they are alleged to have behaved in this complaint. It would be absurd for them to allow this conduct to continue if it in fact actually happened. So there are fixes for this, but using this statute in a way that it was not intended, we would argue, is not the remedy. If your honors have no further questions for me, I've completed my argument. Thank you.
Mr. Gibson?
Thank you, Your Honor. Appellee just cited to William Reppy's article on citizen standing, arguing this is a good explanation of the statute. I'd encourage you to turn to page 59 of William Reppy's law review article. Appellee's argument is that a licensed veterinarian is wholly exempt from the statute. That's the same argument that the trial court fought. Well, here's William Reppy. Suppose a veterinarian routinely crops the ears of dogs using only local anesthesia, creating unjustifiable pain. Suppose this veterinarian, sued by an animal activist seeking to enjoin the cruel practice, has been doing so without the informed consent of the dog's owners, possibly committing the tort of trespass to chattels. A court might hold that an activity that is tortious is not a lawful activity under the veterinarian's exemption. Here's William Reppy saying if you commit an action as part of your licensed practice that violates the law, you don't get to claim the lawful exemption. If William Reppy is the authority here, then you should hold that when they engage in actions that violate the law, the USDA regulations, General Statute 14-363, which regulates the humane transport of chickens in intrastate commerce, when they engage in those actions under William Reppy's own understanding of the statute, they haven't acted lawfully.
Well, he also goes on, though, on page 60 to say that the most malicious and grotesque acts of cruelty by the exempted actors cannot be punished, doesn't he?
William Reppy's understanding of the statute is that you have to locate some other lawful violation, some other violation of the law other than the animal cruelty statute or the civil cruelty statute. We've done that here. We've said you're violating federal law. We've said you're violating state law. We've gone chapter and verse on that, and they haven't said that they're following state law. They've said that if you look at the enterprise as a whole, they can still engage in violations of the law. That would be like me driving to the courthouse this morning and saying, well, I'm licensed to drive, I'm engaged in the practice of law, my car's properly registered, and I sped on the way to the courthouse, but that was an action that was part of the process of lawfully driving to the courthouse. That defense doesn't fly. You don't get to say I'm licensed and registered so I get to speed because I'm engaged in an otherwise lawful activity. If you violate the law as part of that otherwise lawful activity, it's no longer lawful, and William Reppy says that.
That would be different if you were the police officer speeding.
I think if
there's another basis for the activity beyond the general license that everyone else has, that enterprise is different than you. The enterprise of a police officer is different from the enterprise of you driving to work today.
So let's suppose the same hypothetical with a law enforcement officer driving to work. Let's say he's running late for Superior Court, and he decides to speed on his way to Superior Court. I don't think he falls within the statutory exemption because the purpose of his speeding is not the purpose of law enforcement. So to fall within the statutory exemption for a lawful activity, sure, if he was going to a crime scene or pursuing someone who's running away from the police, he's certainly entitled to speed. But the question of speeding, again, goes to the purpose of the action. So even if we're looking at law enforcement officers speeding, There's certainly times where law enforcement officers can and should speed, but you don't get to speed just because you're a law enforcement officer. And that's the defendant's argument here, is you get to speed just because you're a law enforcement officer. You get to conduct cruelty just because you're a farm. I think you have to go a step further than that and say when a complaint alleges you're violating the law and you're doing it all day, every day. And what's more, when they talk about remedies, the USDA coming in to inspect the facility, the complaint also specifically alleges that the employees know when the USDA is coming to visit and routinely try to invade USDA inspectors and hide their misconduct from the USDA. That's exactly why the general statute created this private right of action, so that if something falls between the regulatory cracks, private citizens can come to court and sue. And allowing a complaint to survive 12b-6 with these specific allegations. Again, we're not talking about every chicken farm. We're not talking about everyday agricultural practices. We're talking about disregarding poultry industry norms, and we're talking about doing it every day. In fact, the complaint alleges that those cruel actions happen daily, that it was almost every day that cruelty was observed. When we're talking about that, we're no longer talking about your standard farm. We're not opening the floodgates to every single litigant who wants to come to court. And if there's a lawsuit that's brought without a reasonable factual basis or without a reasonable legal basis, the remedy there is Rule 11 sanctions. I think furthermore, just because you survive 12b-6 doesn't mean you survive summary judgment. You can come to court with an affidavit and says, these are the processes we're following. We're not doing any of the things that you alleged. Here's the USDA regulations, so on and so forth. Here's the processes that we have in place to make sure that we don't do this. It's perfectly fine for summary judgment. But again, when we're looking at Rule 12, we have to take the complaint as true. And I just want to be clear when we're
under your construct, as I understand it, you say this might be a summary judgment case, not a 12b-6 case, but under your construct is that you've got to determine whether something is a primary purpose and all that. All of those are factual determinations in your version of how this statute is to be interpreted, which means that there's always going to be an issue of fact for the court to determine. I mean, and it is the court, it's not a jury, because the statute says that the district court judge makes these determinations. But isn't it always, under your construct, some fact to be determined?
I think if purpose is a question of fact, yes, there's a fact issue. And then it becomes the plaintiff's burden to come to court with evidence. We can't just rest on the allegations in our complaint. We'd have to go to court with evidence of the pattern and practices that we're alleging. I think that's a high burden when you look at the complaint allegations here, and what evidence I suspect the defendants would proffer on summary judgment. Just because there's a fact question doesn't mean you can't ever get summary judgment. If there's a genuine issue of material fact, sure, you can't get summary judgment. But the evidence that the plaintiffs are going to need to show here, and the evidence that plaintiffs would need to show in other cases, this is a very high burden to show, especially if you say you look at the activity as a whole. Well, again, the complaint alleges the activity as a whole is unlawful and not for an exempt purpose. But once you get to that level, for us to produce the evidence, Case Farms just denied here that their management knows this and condones this action. I assume that they could get someone in a deposition or an affidavit at summary judgment and say, this is not what we do. We'd then have to produce some evidence beyond just the allegations of our complaint. I think that's part of the natural filtering process of allowing litigation to proceed in court, that we have to come to court with the facts, with the evidence. We have to show this is what they're doing. And if I'm candid, these sorts of allegations are going to be difficult to prove. One last point, I think it's important to note that the federal government, the USDA, in its bulletin on treatment of live poultry before slaughter, specifically ties humane treatment and food safety together. It says that inhumane treatment of animals is more likely to produce adulterated products. One of the specific examples it gives is boiling chickens alive. If you're not treating chickens humanely and you're boiling them alive, you're going to be more likely to produce an adulterated product. Now, the question I hear from opposing counsel is, well, why would they do that? Well, when you're processing 200,000 chicks a day, if you lose 10 or 100 or 200, that's an acceptable loss. If you're processing 20 chicks a day and you lose one, maybe that's not an acceptable loss. It cuts into your bottom line. Again, you've got to look at the facts in the complaint here, the facts as alleged. You've got to apply the law as written. And when you do that, you see the facts alleged in the complaint cross the threshold that this statute requires, and that's why the trial court erred.
Chapter 19A creates a private remedy for any person. Who's the any person in this case? The caption is LLC. Who's the any person? You talked about a citizen's remedy. It's a standing issue, right?
That's correct. So
nobody puts their names on these complaints. They put an LLC's name on the complaint. So who's the citizen? Or
so
who's the person?
the definition of person in the statute, 19A-1, says the term person has the same meaning as in GS 12-3, which defines person to include natural and corporate persons. So legal impact for chickens would be a person. There's in fact a case on point, I believe we cited it in our brief, Justice for Animals, I believe that the federal government, the USDA, in its bulletin on treatment of live poultry before slaughter, specifically ties humane treatment and food safety together. It says that inhumane treatment of animals is more likely to produce adulterated products. One of the specific examples it gives is boiling chickens alive. If you're not treating chickens humanely and you're boiling them alive, you're going to be more likely to produce an adulterated product. Now, the question I hear from opposing counsel is, well, why would they do that? Well, when you're processing 200,000 chicks a day, if you lose 10 or 100 or 200, that's an acceptable loss. If you're processing 20 chicks a day and you lose one, maybe that's not an acceptable loss. It cuts into your bottom line. Again, you've got to look at the facts in the complaint here, the facts as alleged. You've got to apply the law as written. And when you do that, you see the facts alleged in the complaint cross the threshold that this statute requires, and that's why the trial court erred.
Chapter 19A creates a private remedy for any person. Who's the any person in this case? The caption is LLC. Who's the any person? You talked about a citizen's remedy. It's a standing issue, right?
That's correct. So
nobody puts their names on these complaints. They put an LLC's name on the complaint. So who's the citizen? Or
so
who's the person?
the definition of person in the statute, 19A-1, says the term person has the same meaning as in GS 12-3, which defines person to include natural and corporate persons. So legal impact for chickens would be a person. There's in fact a case on point, I believe we cited it in our brief, Justice for Animals, I believe, versus Lenoir County ASPCA. It was I believe a Judge Tyson or Judge Inman decision from this court. If it's not on the briefing, I'd be happy to provide it, that addressed standing for a corporate entity and held there was.
Next question is, I asked your opposing counsel about the enforcement of this as executive branch function stuff. What are your thoughts do you not have to have relator status to actually have a remedy?
I think under the North Carolina Supreme Court's holding in Dan Forrest, the General Assembly has broad powers constitutionally to create a private right of action. The injury in fact requirement of federal Article 3 standing doesn't apply in North Carolina. So if the General Assembly passes a statute that says a real party in interest shall be held to include any person even though the person does not have a possessory or ownership right in an animal. The General Assembly has the ability under our state constitution to expand standing to include people in that instance. Dan Forrest has made that clear. It relied on a lot of precedent from this court about the General Assembly's authority to confer standing on.
The question is the remedy. Say you get the injunction for 10 days. And at the expiration of 10 days, everything goes right back. It's got to be an executive branch actor that carries out an actual remedy in the case. Otherwise, you're looking at a pause.
I think we'd hope, if all we got was a pause, I think we'd still believe that this litigation was worth it. But I think we'd hope that if we went to court and got an injunction, that hopefully the USDA or the Secretary of Agriculture would take notice. I don't see anything in the
They,
statute.
they can give your clients the authority to prosecute those cases on their behalf, right? Through having gained relator status.
I believe they can, and I think that's what the General Assembly was trying to do here. When you look at the original enactment of this statute in, I believe it was 1868 or 1869, the statute that the 1969 version was modeled on, it actually specifically conferred statute to animal welfare. I believe there were societies for protection of animals at the time. It allowed them to actually go and arrest people, which is about as far as I've ever seen the General Assembly give private individuals a right. On the injunction point, and I realize I'm way over time, so if y'all want to stop me, I'm happy to stop, but I think that the court says that the statute says that there can be a permanent injunction. When it comes to removing the animals, I hear defendants' concern there, but the statute requires that the court find by a preponderance of evidence that even if a permanent injunction were issued, there would still exist a substantial risk that the animal would be subjected to further cruelty if returned to the possession of the defendant. That's what they've got to find to transfer possession of the animal. That's not what we're looking for here. I think ultimately, if you ask my clients, wave a magic wand, you can get whatever relief you want, we'd say, and we say this in the complaint, they need to employ a few more people in their slaughterhouse. They need to employ a few more people in their hatchery. And if you add a few more people, these sorts of mistakes, and candidly, I think a lot of this stuff is a mistake that they're making, these sorts of mistakes would stop happening. If you had more people in the slaughterhouse, you had more people in the hatchery, these chickens wouldn't be going into the scalder alive. Obviously, we allege in the complaint that it's intentional.
I think I understand your position.
Sorry. Thank you, Your Honor.
Thank you all for spirited arguments.
All rise.